case against former President Jacob Zuma has been postponed to the 17th of May. This is pending the outcome of his latest bid to have lead prosecutor Billy Downer removed from his trial. The Pietermaritzburg High Court made the ruling yesterday in Zuma's absence after his lawyers told the court that he was ill. Our reporter Nkosikhona Duma was at court. He found the story.
It was almost 2 hours of legal wrangling with the legal representatives of former President Jacob Zuma arguing that the trial proceedings against him should be postponed until the Supreme Court of Appeal makes a decision on his reconsideration application.
Firstly, as we have set out in our heads, the case really rests on the relationship between what is happening in the FCA and Section 17. The Lordship is quite correct. If anything, the refusal or dismissal of that petition by the SCA has removed any confusion as to whether we are now in the land of the Criminal Procedure Act or in the land of the Superior Courts Act. It's very clear that we are now in the land of the Superior Courts Act, Section 17. And there's a reason, my Lord, why Section 18 follows Section 17 in the Superior Court Act. It is because the two sections are symbiotically intertwined. Because the opening words of Section 17, of Section 18(1)(a), as your Lordship will know, say that whenever there is an appeal or an application for leave to appeal or an appeal. In other words, is the application for leave to appeal that has been dealt with.
Zuma had approached the court following the dismissal of his bid to have State Prosecutor Billy Downer removed from the case by the Pietermaritzburg High Court. The states argued that another postponement would cause further frustration to the case.
The effect in delaying the trial will be to achieve what this court, the SCA, the legislature, and the interests of justice seek to avoid. And that is perhaps our main point, my Lord. It makes this case special, given its background in the delays and the effect of the countless applications, all of which have been refused. If, in a case such as the present, appeals during the trial are not allowed, policy reasons say that that's good. Your Lordship has found that is good. The SCA has confirmed that is so. If this application for postponement is granted pending further appeal procedures, that means that the effect of your Lordship's judgment, giving effect to the policy of the legislature and good order in court trials, that would be frustrated. And that is the central frustration in this case, because we just can't seem to get anywhere, because even though the law doesn't allow what is now happening in this court, nevertheless, this court is being asked to postpone the matter.
However, Judge Pietermaritzburg begged to differ. He said delays in the start of the trial as a result of Zuma's use of the appeals process did not amount to the abuse of the law.
It would be a delay which would not be unreasonable, but in our constitutional democracy, on the laws it presently stands, unfortunately unavoidable. When weighing all the relevant facts and circumstances alluded to by the parties, the conclusion I have reached is that the trial must be adjourned to allow the reconsideration application submitted to the President of the SCA pursuant to the proviso to Section 17(2)(f) of the Superior Courts Act to be disposed of.
Judge Goon has pinned the 31st of May as the trial date, pending the conclusion of Zuma's Supreme Court of Appeal reconsideration application by May 17. For Newzroom Afrika on Channel 405, I am Nkosikhona Duma in the Pietermaritzburg High Court.